Welcome to the first video of 2017. Today we're going to discuss something pretty important. Buying a house, one of the most important investments of many of our lives. So the lovely phrase that we hear a lot is marry in haste and repent at leisure. This is a lovely idiom that's extremely relevant to the property sector. A lot of buyers rush into signing sale and purchase agreements without really understanding what it is that they are signing. Sale and purchase agreements that are given to us by the real estate agent to sign don't only talk about the price of the property, but there are many other conditions in there which we are agreeing to when we sign as the purchaser. The problem, of course, is that when purchasers are buying properties, they are told by real estate agents many a time that they must put in their offer immediately as there are other parties who are interested. So while the purchaser is totally driven on getting the right price and making sure that the deal is good for them, they sometimes forget to realise that there are salient features on which they should have sought proper legal advice prior to entering into the agreement. Often I find that buyers don't realise that some of the conditions that are extremely important that are in the agreement are things like finance, the condition for finance, how long you've got to have that condition satisfied, there's the LIM report condition, builder's report conditions, and any other conditions that you wish to put in the agreement. Many a times the agent has drafted the agreement unbeknown to the purchaser. It's usually for the vendor's benefit and the purchaser simply thinks they are agreeing to a price. They sign this without taking legal advice first. This is extremely detrimental and has caused many problems for purchasers after they've already signed. So a lot of people come and say to me, "Hey Farah, isn't this just a standard agreement?" Well, if it's a REALS form, which is one that's approved by the New Zealand Law Society, then it probably is standard agreement. However, those standard terms can be varied. They can be changed and varied to fit your circumstance. You would have noticed that there are many small conditions in fine print that are written all through that agreement, and I'm sure none of you have actually read the entire agreement. But guess what? I have. Not only have I read the agreement, but I've understood and learned in depth through my university degree the actual implications of many of those clauses. That's the reason why it's imperative that prior to signing an agreement or putting an offer on a property, you should seek independent legal advice. You should take the agreement, the draft agreement, to your solicitor and discuss it with them at length. The other thing that I often find happens when sale and purchase agreements are signed is that purchasers come to me and say, the agent and the vendor have promised such and such. They've either promised to clear excess rubbish, cut the trees, leave furniture in the property, all sorts of things, of course, which aren't written up in the agreement. Upon writing to the vendor's solicitor and saying, look, my client says that all these things should be included, most likely the vendor's solicitors will advise the vendor that, look, it's not in the agreement and therefore you're not legally obliged to do any of it. Many a time my clients will come and the purchasers will say to me at no end, but Farah, it's a gentleman's agreement, they have to honour it. They told me this is what they'd do. Of course, there's nothing that I can do to help you at that stage. It's too late. It's not in writing. Sometimes vendors or agents will honour what they've said verbally, but 99% of the time they won't. Vendors sometimes offer a lot of things without realising that they don't actually have to provide it, and once they've taken legal advice, that's when they realise, actually, that's not something that I want to do now. So keeping all of this in mind, it's really important when you're going to purchase a home that you discuss with your lawyer what sort of conditions you are going to need. Some people say that they've already got finance, they've got a pre-approval for finance, and one of the really important things I tell them is please still put a finance clause on your agreement, even if it's short, 2 or 3 days. The reason is if you hold a pre-approval for finance, then your bank has said to you, yes, I will lend you XYZ money. But they have not necessarily said they'll lend you that money on the particular property that you go and enter an agreement for. If that particular property ends up being a leaky home, it ends up having development plans in the future that are in the pipeline and that the government have put proposed plans, or if there's anything else that might be affecting the value of the property in the future, a bank could likely say, yes, we will give you the money to purchase a property, but not on this property. And lo and behold, you're now in problems because you've already signed an agreement with no finance clause. One of the things that I think is important is that if you're in doubt, put a due diligence clause in. A due diligence clause allows you to exit an agreement for any reason whatsoever. You could just have a simple change of heart, really, and you would probably be able to get out on a due diligence clause. So if you are going to sign an agreement without showing a solicitor, then the least you should put in is a due diligence clause to allow you 4 or 5 days to consult your lawyer and then to sign and then to proceed with the agreement. The problem in this market really is it's not the purchaser's fault. Agents put an immense amount of pressure on purchasers to sign agreements, and it's not also the agent's fault either. The nature of the market is that there are many buyers for one property. And keeping this in mind, if a purchaser doesn't act quickly and does wait a week to instruct their solicitor to get legal advice, of course by then the property's sold and they're back to square one looking at another property. I also understand that a lot of purchasers are very hesitant to spend a lot of money speaking to a lawyer prior to having the agreement offer put in because they're not sure if the vendor will even accept the offer. And in that case, they've spent money at their lawyer's office, maybe $300, $400, $500 or in excess to get some advice, which really didn't work out for them. Again, back to square one. Due diligence is a really good clause to put in. It allows you an out, so if you put that in there, later on you can come and discuss that with your lawyer. But really the $300 or $400 or $500 you are going to spend for an investment of at least over $500,000 is definitely well worth it in the long run. It's something I strongly suggest that you do. So the next issue is it only the purchaser who should seek legal advice prior to signing a sale and purchase agreement? Absolutely not. It's just as important for a vendor to also seek independent legal advice prior to signing an agreement. The reason is, many of you who are selling properties through auction are already aware that real estate agents are now sending your auction agreement for approval by your solicitor. The reason they're doing this, of course, is an auction agreement is unconditional. All the warranties the vendor makes in that agreement, they have to comply with. Equally important for the purchaser in an auction also that it is completely unconditional. So they should take independent legal advice prior to going to the auction. But really, what's the difference between an auction and a normal sale and purchase agreement? Not a hell of a lot. So the advice that you take should really reflect any agreement that you sign prior to signing. I have a lot of clients who are investors who say to me, well, Farah, I am signing these agreements daily, I understand how it all works. But keep in mind, just because it's a REALS form, one of the Law Society standard forms, does not mean that you are aware of all the conditions in there. A lot of times you may look through the fine print and there are things that have been crossed out or varied in the fine print of the agreement. It's really important that those aspects of the agreement are fully understood prior to you signing to them. The other important thing for investors, of course, is that a lot of the things that they are buying are not standard forms. Their vendors, lawyers have drafted specific sale and purchase agreements for that development or the subdivision for that to go ahead. So in that case, it's again even further more important that you really understand it. I've seen agreements that are, that thick. And I've said to clients, if you want me to read this before you sign it, or even after you sign it, it's going to take some time and it's going to cost money. But at the end of the day, an agreement that thick, it really does need to be looked at. Unless we've read it, we don't know what it says. So it's well worth spending a couple of $1,000s getting that read, understanding the terms and conditions prior to going ahead. Something else that's really interesting in this area is that a lot of times clients will say that the agent signed it or the agent drafted the agreement, and somehow they believe, either the purchaser or the vendor, they believe that that absolves them of any of the warranties or conditions in the contract. Of course, this just really isn't the case. The agent acts on behalf of the vendor, they act on the instructions of the vendor, and they simply do what the vendor tells them. It is the vendor who is responsible for the warranties in the agreement, and if a purchaser signs the agreement, it is the purchaser who is responsible to understand what they are signing. So to simply throw our hands in the air and say it's all the agent's fault really won't cut it when things do go wrong on settlement day. So to sum it all up, really, the Latin phrase caveat emptor is what really governs this area of law. And caveat emptor simply means buyer beware. You enter the agreement at your own risk, so it is important that you make all the inquiries that you need to do prior to signing the sale and purchase agreement. On top of all of this, the only thing I can advise strongly is to please seek legal advice prior to signing anything, whether it be a sale and purchase agreement or any other type of agreement. It will save you a lot of money in the long run. I hope you found this video helpful and informative. Until next time, I'm Farah Khan, your lawyer.